This is beyond the bounds of professionalism, and it's just flatly preposterous. We're going to go through the motion for new trial from Kouri Richins' lawyers. We're going to go to the tape on some of the moments that are highlighted. There are numerous transcripts that are attached here. We're going to look at the transcripts and we're going to go through all of the things. We are going to go through this very spicy motion, and then we're going to take a look at what Judge M filed and talk about that a little bit more in depth. Wendy Lewis, Catherine Nestor, and Alexander Ramos are filing the defendant's motion for new trial. Pursuant to the Utah criminal rules and rules of civil procedure, Kouri Darden hereby moves this court to grant a new trial due to irregularities in the trial proceedings and cumulative error, and presents to the court the attached video clips and documents in support of her request. I have all of the documents. We do not have the video clips, but I think that we can find them based on the things that they say. Ms. Richins' convictions should be vacated and a new trial granted for the following reasons. Number one, the court's clear demonstration of bias in favor of the state displayed before the jury deprived Ms. Richins of a fair trial. Two, the state's repeated reliance on other crimes, wrongs, or bad acts, and the omission of evidence proving Ms. Richins committed wide-ranging financial crimes over numerous years in several general categories went far beyond the court's pretrial rulings, violated rules 401, 402, 403, 404B, and resulted in substantial undue prejudice, denying Ms. Richins a fair trial. Start with that. Too much prior bad acts evidence is one of those things where courts of appeals are like, I don't like it. No likey. That's all gray zone. And what is too much for any particular court of appeals on any given day can vary. There is no bright line rule on this. So this is going to be your strongest argument. Lead with it, because the rest of this just comes off truly as sour grapes to me. 3, cumulative error. Good luck with that. Sure, Jan. The court's repeated assistance to the prosecution and disparate treatment of defense counsel before the jury denied Ms. Richins her right to a fair trial. Throughout the trial, the court repeatedly interrupted defense counsel, corrected counsel in ways that suggested to the jury that counsel was mishandling witnesses, assisted the prosecution with its objections, and curtailed the defense's objections. On at least one occasion, the court did so in a manner that made clear to the jury that it was offended by defense counsel. If I don't see the example of this, I will lose my mind. They say the misconduct created an appearance of bias against Ms. Richins and in favor of the prosecution, depriving Ms. Richins of a fair trial. In this matter, the court engaged in repeated conduct that denigrates defense counsel in and out of the presence of the jury. The court was often impatient, critical, and hostile towards the defense and only the defense. Footnote 1. And this footnote made me lose my mind. Let me know if I'm being overly sensitive on this, because I am a little feisty over kid stuff. So let me know if I am being too critical and if I read this too critically. Footnote 1. See trial transcript day 12, page 146, line 14 through page 148, line 16. At the bench, the court angrily criticizes Ms. Nestor's objection, telling her to, quote, unquote, slow her roll, and reminding her that to, quote, read the ruling that I issued yesterday and to try and avoid plain error to help your client, end quote. Further, the court tells Ms. Nestor that she needs to wrap it up because, quote, I have a parent-teacher conference to go to, and my son barely recognizes me, end quote. That's footnote 1. Was that necessary? No. Do I think that that was dirty? Yeah, I think that's dirty. Also, we're not hearing the way the court is saying this. Can I imagine, and have I been this parent who has worked so much that I've joked, look, man, if my kids don't see my face, they're not even going to know who I am. Like, that's how much I'm working in this trial. Yeah. And both Miss Nestor and Miss Lewis have talked about the fact that they have kids. To try to do that to another parent is horrific. They go on to say that the court frequently interrupted defense counsel, telling them to, quote, pause or, quote, focus. See attachment A, a video clip of trial day 4 at 2:07. The court interrupts Miss Lewis in a demeaning manner, saying, please pause. Seconds later, the court follows an interruption of the prosecution with an apology. When Miss Lewis expresses frustration at the court for changing a ruling made at the bench, she is told twice to, quote unquote, stay focused and don't do that. Please stay focused.
It's two pages.
So it did say celebrate. I thought it did.
Please pause.
I'm sorry.
Is this the exchange where the judge told her to please pause? So the court is asking the prosecution, show me what you want to admit to the jury. And the prosecution's like, we're there now. And she's interrupting the court, speaking out of turn, saying, but the document says celebrate on it. And so the court said, please pause. We are trying to get to step A before we get to step B. She knew she was interrupting the court.
And I don't think just extracting celebrate, the word celebrate, solves the problem. You ruled from the bench just a minute ago that this could be used as an impeachment document.
I did not. I said specifically you cannot use it if it's not admissible because there's no foundation for it.
Well, then we discussed it further, and you said go ahead and show it to her and ask her if she remembers it, and then the text.
That was not in the context of impeachment. That was in the context of the Mr. Bloodworth and his direct using it to refresh a recollection of a witness who may not specifically recall the content.
I misspoke. That's what I meant. To use it to refresh her recollection. And you ruled that that would be appropriate. Well, then Mr. Bloodworth attempted to change your ruling, which happens a lot, which is what
Don't do
gets
that.
me.
Please stay
well, that's
focused.
what gets me frustrated.
Please stay focused.
I think your ruling was appropriate, that it can be used to refresh your recollection.
That's not what you ruled.
You ruled, and I think your ruling should stand.
You understand that this will limit your use of this document in impeachment.
That's fine.
Okay.
She said, you ruled at the bench A. He said, that is not what I ruled at the bench. And she says, you're changing your ruling at the bench. And he's saying, don't do that. That's not what I did. Because she's misstating his ruling and he's trying to bring it back. The motion continues saying, never was the state told to focus. The state perfected the art of saying less and sitting down and shutting the fuck up. During day 4 of the trial, the court interrupted defense counsel on 24 separate occasions while only interrupting the state 13 times. This normally may not show bias, but the interruptions of defense were curt, cutting off statements and arguments, while interruptions of the prosecution were followed by apologies, were often to help with logistical issues or to aid them with objections. This pattern followed throughout the trial. On day 1 alone, the court interrupted the defense 36 times, as opposed to interrupting the prosecution 20 times. A full review of the trial transcript demonstrates that this disparate treatment of the defense was persistent, prejudicial, and well outside the bounds of neutral courtroom management and administration. The thing is, y'all tried to make fetch happen. Fetch wasn't happening, and now y'all are mad that it didn't happen. They go on to say, in addition to speaking in a disparaging and condescending manner to the defense, the court would also reframe arguments in a way to help the prosecution. Did y'all see this happening? Because with both counsels, there were times I saw the court saying something to the effect of, let me make sure I'm understanding you. And the court would reiterate what either of the attorneys had said and make sure that he was clear, because there were frequent times where the court was saying, just so I'm understanding, what you're saying is A, B, C. They go on to say, one strong example of this took place on day 10 of trial, when the defense was attempting to elicit testimony of the victim's prior use of pain pills. They say not only did the court interrupt the defense, But it also continuously rephrased the argument, insisting that the defense use the term illicit street drugs, defining such drugs in a way that does not include prescription pain pills. During this argument, the court did more than frame the issue in terms favorable to the state. It affirmatively accused Ms. Nestor of knowingly misusing the court's chosen definition, a definition unsupported by any expert testimony or evidentiary basis, and instead supplied by the court itself. The court accused Ms. Nestor of knowingly misusing language. I'm shocked it only happened once, because that was literally half of the defense strategy. Other examples of the court speaking down to defense counsel are noted. Day 9, page 20, where the court accuses Ms. Lewis of intentionally ignoring what the court is saying and informing the defense as an answer to the objection that they can call their own witness in their case, thereby burden shifting. At attachment A, day 11, 49 minutes, the court didn't, so now we're skipping to a different day, day 11. The court didn't simply rule on Ms. Nestor's objection to relevance, but commented on the objection in an extremely disparaging and condescending manner. I'm sorry. You want to say that the court was condescending? And the court shot down an objection by Ms. Lewis during closing. Why is this all one sentence? Interrupting her in the process and strongly saying, please be seated. This was particularly prejudicial to the defendant as it was in front of the jury. Is that the only instance of this that's in front of the jury?
But she returned from somewhere to their bedroom, unlocked her phone, put it on speaker. There's no call detail records showing a call at that time. But she may have called on Wi-Fi, somebody. That would not appear in the call detail records.
Is that a reasonable inference from the evidence? She put the phone on speaker. A Wi-Fi call wouldn't show up on the Verizon records.
Somebody. That would not appear in the call detail records.
It wouldn't.
It would appear on her phone if her phone had not been deleted.
Objection, Your Honor. These are facts that are
Overruled.
not.
Please have a seat.
Overruled, please have a seat. This was particularly prejudicial to the defendant as it was in front of the jury, indicating that the court was angry with the defense and making it clear that objections during closing would not be tolerated. The state then went on to make several objectionable statements during closing, leaving the defense with no remedy in front of the jury. Footnote 3, Ms. Nestor did make a record outside the presence of the jury after closing arguments were complete as to the improper comments made in the state's closing, although, of course, by then, the jury had already heard the improper arguments. Trial judges sit high above everyone else in the courtroom. They preside and they decide. They welcome and protect the jurors, accommodate their schedules, and make sure they have everything they need. The trial judge often banters and jokes with the jury, and this case was no different. The jury looked up to the trial judge, laughed at his jokes. The horror. I am aghast. The jury chuckled at Judge M's jokes. They engaged favorably with the judge throughout the trial. A full review of the record makes it clear that the court let it be known to the jury that it favored counsel for the state and their positions. When the prosecution raised concerns, the court often accepted, clarified, or helped frame them. When the defense raised concerns, the court often responded with interruption, correction, skepticism, or curt commands to move on. I don't know if this is a criticism of the court, though. Some of this has to do with the lawyering, because the lawyering was different and not everything raised by the defense was valid. And so, yeah, constant interruptions for invalid, extemporaneous arguments are going to be met with, thank you, move on. In addition to the court's treatment of counsel, a full review of the trial transcript shows multiple instances where the court suggested that defense objections could be resolved by the defense calling their own witnesses, thereby shifting the burden by instructing them to put on a defense. Do you have any examples, or are we going on vibes? But the defense kept trying to do this throughout the trial, and at the end of trial, we clocked why. The defense was trying to use the prosecution witnesses as their own witnesses, which when you can do that in cross-examination, I will always give attorneys props for when they can make a witness their own. You've seen me talk about this with experts, where an expert on cross-examination ends up getting out the other side's points that they want to make. And so they take that expert and make them their own and get out the things that are beneficial for their case. But what repeatedly happened during the Richins case is that the defense wanted to embiggen the scope of direct, and the prosecution was curtailing the direct examination to just what they needed to have in. The prosecution did, I think, a very good job of staying focused on exactly what proved their case and not getting into the weeds. And then the defense wanted to open the cross-examination into areas that weren't covered by the prosecution. And the correct response to that is, then you can call this witness. In a particularly heated debate with defense counsel regarding argument over the state's request to put in additional statements by Carmen Lauber after she had already taken the stand, the court told defense they should recall Ms. Lauber in their case if they wanted to question her on those statements that the state did not put in during her testimony. See attachment A, day 11.
During cross-examination, it's fully within our right to pick out portions of this interview.
But you can recall her, right?
I don't think that's our job to recall the state's star witness. They had her on the stand.
I just asked.
Is this the heated exchange?
It's fully within our right to pick out portions of this interview.
But you can recall her, right?
I don't think that's our job to recall the state's star witness. They had her on the stand.
I just asked you a yes or no question. Would you start there for me?
Could we recall her? Yes, that is something that could be possibly done. I don't imagine what world a defense would do that. But
and correct me if I'm wrong, you had the transcripts when you cross-examined her, right?
yes, but so did they. And the appropriate way to do it would have been to try and rehabilitate her on redirect, which would have then given me a chance to.
The legal problem here is that it seems that Miss Lewis wants to play Go Fish, and the prosecution is playing chess. And so she wants to be able to narrow this down and be like, go fish. We'd like to ask Carmen Lauber about this. Go fish. And the prosecution's like, hey, there's multiple ways to do this, and we're going to do it a different way. She does not like the way that they want to do it. But what the prosecution is proposing, this is all going to Carmen Lauber. What the prosecution is proposing is, because the defense opened the door, the defense brought in all of the cross-examination insinuation that the statements made by Carmen Lauber were because the police were bullying her in her interviews. It was the police were saying this and you were just going along with it. And so the prosecution said, fine, we'll just show the interview and the jury can decide for themselves. But they don't have to use Carmen Lauber to do that. They can just show the interview. And Ms. Lewis is like, but no, we don't want you to do it that way. Well, right.
Yes, that is something that could be possibly done. I don't imagine what world a defense would do that. But
and correct me if I'm wrong, you had the transcripts when you cross-examined her, right?
yes, but so did they. And the appropriate way to do it would have been to try and rehabilitate her on redirect, which would have then given me a chance to go into other statements.
They sought to, and I limited their ability to put in the whole 900 pages.
That's not how you rehabilitate. You rehabilitate by asking questions. It's not by putting in an entire transcript.
Well, you can do it, for example, by admitting prior consistent statements. And so I need
the defense has miscalculated the rules of evidence in this moment.
I need you to stay focused on that rule for a moment. I know I'm interrupting you.
Yeah, you are.
I don't understand how you...
The defense, when they start to see that maybe argument A isn't going their way, they immediately switch into argument B and then argument C and then argument D. And the court is like, no, we need to resolve A and then B and then C.
I just need you to stay focused on that rule for a moment. I know I'm interrupting you.
Yeah, you are.
I don't understand how you think they were.
The court's face. She's like, yeah, you are. And the court's like, seriously right now?
I'm interrupting you.
Yeah, you are.
I don't understand how you think they were supposed to admit prior consistent statements.
Through testimony.
That's not
no.
a prior consistent statement. The whole
No. Oh my God. The court is trying to now do Rules of Evidence 101.
statements.
Through testimony.
That's not a prior consistent statement. The whole reason we have the prior consistent statement rule is because the testimony goes in a different direction.
The prior consistent statement.
Or there's a charge of recent fabrication or undue influence.
And I think requesting us to recall her is burden shifting. That is not what our job is. That's not what we needed to do. They needed to take care of their witness when their witness was on the stand.
And
Okay, now she's
you
heated.
objected to the addition of any part of the transcript at the time they offered it,
For the
correct?
same
Yes.
reason. They offered it after she was off the stand.
Had they offered it the 900 pages when she was on the stand, you would have said, okay.
No.
I would have said you need to cross-examine her, redirect her and rehabilitate her testimony.
And so how do you see the rule regarding prior consistent
Right. She's saying that there's no way for the prosecution to do this, but either way, they did it the wrong way.
statements working?
They need to get it through her. They could have put on
But
prior
you
consistent statements through her. And then
really don't understand. You're saying that prior consistent statements never come in. You only can ask questions. Please help me.
Right. She's just misstating the law to the court.
I don't understand. I'm sorry, Your Honor. I really am not following what you're trying to say. I have
Because you're misstating the law, and then the court says the law, and then you say, what?
never seen this done any other way than through a witness. That's why we have witnesses. If not, why have any witnesses? Let's just hand the jury all the evidence. Let's hand
That's
them all
not-
the transcripts of.
Ma'am, no.
No, be fair to how the rule works. Somebody testifies on cross-examination. Defendant makes a charge of recent fabrication, and then the
And
proffering
then?
party has an opportunity to offer prior consistent statements to rebut the charge of recent fabrication.
So again, the defense is saying the court was shutting us down. The court was being demeaning. And what I see is not what the defense is portraying. I just disagree. They go on to say, at time, the court went so far as to tell the defense to put the defendant on the stand rather than allowing certain lines of questioning. See trial transcript day 7 at page 240, lines 10 and page 265, line 2. That must have been at sidebar because they're putting in transcript, not video. But there were times the defense was trying to get in the defendant's statements to law enforcement. You cannot put in your own party's statement. So a defense attorney cannot put in their client's statements to law enforcement. So if you want those statements in, the only answer is then your client can testify. In addition to disparaging defense counsel, the court repeatedly aided the prosecution by supplying objections that the state had not made, and on at least one occasion, sua sponte, of their own course, objected on the state's behalf and then sustained its own objection. They say, see attachment A, day 1, page 117, page 220, day 6. So these must all be at sidebar. Day 6, day 9, day 13, and day 13. Although a trial judge may control the courtroom and rule on objections, the court may not abandon the role of a neutral arbiter and assume the role of advocate for one side. When the court supplied objections for the prosecution and then sustained those objections, the court did more than manage the proceedings. It communicated to the jury that the state's position had the court's approval and that the defense's questioning warranted judicial intervention, even when the prosecution itself did not object. That appearance of alignment with the prosecution is precisely the type of conduct that can infect the fairness of a trial and requires a new trial. Overall, based on the court's conduct, it often appeared that the defendant was not facing a single adversary, but rather had to bear the consequence of a judge who at times acted as a second adversary and who appeared to disbelieve either defense counsel or a defense witness. As a result of the court's repeated prejudicial conduct towards the defense in this case, the defendant did not receive a fair trial by a neutral arbiter of justice. Because Ms. Richins, in asserting herein a claim of bias on the part of the judge, the court should reassign the consideration of this motion to another judge in compliance with the Utah Code of Judicial Conduct. The defense is just throwing out there, oh, by the way, you should recuse yourself. The motion for new trial should be reassigned. Generally, that is another motion. And you would request that separate and apart from your motion. So you would get a motion for reassignment and then your motion for new trial. But they kind of throw it in the middle here, and they don't put it in the top of what they're asking for. At the beginning of the motion, they don't say we're asking for reassignment. They just kind of lump it into the middle, which is really not the proper way to do that. Leonard, it's summer, and not only is it summer, but for me, it's summer in the South, and sometimes makeup can feel like way too much. But that's where today's sponsor, Jones Road Beauty, comes in, because they have multitasking, skin benefiting, glowifying, my word, not theirs, makeup that is not only super easy to use, most of it comes in a stick form, and it just leaves your skin looking incredible. So when you're like, Emily, I'm loving the glow on camera. I know, it's the Miracle Balm. It is a really easy way to just get a little bit of glow on your cheeks. Plus, in keeping with simplistic, easy to use, making your skin look amazing makeup, Jones Road has just launched a foundation stick, which means if you are looking for a little more coverage, but still a fresh skin makeup routine between your Miracle Balm and your foundation stick, completely handled. Plus, they have a gorgeous new location in Nashville. So if you're looking to check out Jones Road locally, you can always see if there's a location open near you. Leonard, what you're gonna love about Jones Road Beauty is that it's modern day makeup that's clean, strategic, and multifunctional for effortless routines, which we absolutely love. Plus, for a limited time, you get a free gift with your first purchase when you use code EDB at checkout. So just head to jonesroadbeauty.com and use code EDB at checkout for your free gift. And if they asked how you found out about them, let them know it was the Emily Show. Case briefs. And now, let's get back into it. States' repeated reliance on other crimes, wrongs, or bad acts, and the admission of evidence proving Ms. Richins committed wide-ranging financial crimes over numerous years in several general categories went far beyond the court's pretrial rulings, violated Rules 401, 402, 403, and 404, and resulted in substantial undue prejudice denying Ms. Richins a fair trial. 401, relevance. 402, admissibility of relevant evidence. 403, exclusion of evidence for prejudice, confusion, waste of time, or other reasons. So 403 is, hey, this is too prejudicial, which is fair here. 404B is the other bad acts, not the character evidence. That's 404A. So 404B is all of the other crimes, wrongs, or acts. 404B is really where they're living here. I don't know why they're throwing in 401 and 402. Because really what they're focused on is 404B. Prior to the trial, the defense filed motions in limine seeking to exclude from trial evidence of over 30 other crimes. Did you hear evidence of over 30 other crimes committed by Kouri Richins? 30 other crimes, wrongs, or bad acts connected to Ms. Richins' business or her financial dealings over a period of several years. On January 7th, 2026, the court held a hearing to determine to what extent all Ms. Richins' alleged financial misdeeds spanning years before Eric Richins' death could be admitted at trial. The court gave the state some general guardrails attempting to avoid 404B issues at trial. Oh, you mean the court ruled against the state? Why can't, and now this motion has pissed me off so much. Here's the thing. Why can't you just say that the court limited what the prosecution could present? Even this is twisted. Even this is just like the court was attempting to avoid 404B issues at trial. Not that the court narrowed down the evidence. Nay. The court was trying to avoid 404B issues at trial. See attachment B, pretrial hearing transcript. I think we just go to the transcript now. Shall we continue our way through the defendant's motions in limine? Bloodworth, yes, sir. Court, okay. I believe we're up to number 8, which seeks an order excluding a number of exhibits that have been disclosed by the state related to the property located at 299 East 100 South in Heber, Utah. In its opposition brief, the state states, quote, shortly after Eric Richins' death, the defendant dangled the prospect of home ownership to defraud her best friend since middle school out of $45,000 to service accounts receivable debt and cover other expenses, end quote. A lot of these were sealed prior to trial. So we didn't see all of the Bloodworth filings. Let me be absolutely transparent. I think these documents showing that this asset held by Ms. Richins was highly leveraged, and then arguments related to if she didn't get some money fast, this was among the things she was going to lose to foreclosure. I think that's fair game. I think it's probative, not properly excluded under 403. Where I pause and have concern, this is still the court, is an argument that this constellation of facts arising from these exhibits are part of an effort to defraud her best friend out of $45,000. Because you stole my motherfucking house is visceral. There is a visceral reaction to you're stealing from your best friend. And I can't well articulate why that viscerally hits different, given the fact that Kouri Richins at this time was pending trial for murdering her husband for financial gain. But the extra insult of, and you stole your best friend's fucking house is different. The court is saying in this ruling, where I pause and have concern is an argument that this constellation of facts arising from these exhibits are part of an effort to defraud her best friend out of $45,000. This is not a charged crime, not in the murder case. Fraud is a bad act that not only isn't charged in this case, but is also related to crimes that are charged in this case. So now we have the dangers of inviting the jury to draw an improper propensity-based inference on the one hand and confusing them about which fraudulent acts they actually need to make findings on regarding the other. Why do you need to make that argument versus just showing? Bloodworth, my first reaction to that, Your Honor, is I don't know that credits the juries enough. I think juries can distinguish between that, certainly. Bloodworth goes on to say, and with the court's seventh ruling, the only frauds, if you will, is the fraud related to the true stage application. But I guess I'm trying to say is why is it probative of anything that she was seeking to defraud her best friend unless it's to show she's a fraudster? So the court is trying to limit the language that Bloodworth wants to use. Not that Kouri is trying to defraud her best friend. Just stick to what Kouri did. The text messages between Kouri and Chelsea and the money that she took. Bloodworth, it's to show how blisteringly desperate she was. Damn, it's just so good. How blisteringly desperate she was. This is why the defense is mad. It's because they just can't do this. The court says that arises from the financial situation. Bloodworth, no, Your Honor. The court, that's why you get so much cumulative information there. Bloodworth, no, Your Honor, it's not. The court, I disagree. I've read your brief. We don't have time for this. If you want to make a record, I'll let you, but hear me out for a second. Bloodworth, yes, sir. Look at this. The court is saying to the prosecution, I've read what you had to say. I disagree. I'll let you make a record briefly, but we don't have time for this. Oh no. The disparagement. I'm being facetious. Mr. Bloodworth responds, yes, sir. Does not launch into any additional argument, does not start to argue with the court, just says, yes, sir. The court, this position that you get to say all the awful things she did as evidence of how desperate she is, I'm not persuaded. Oh, look, the court's not persuaded. You have to be more specific and much more strategic about why that particular bad act is worth the danger of the propensity inference. And this one just doesn't overcome the danger. You have so much evidence of how desperately bad her financial situation was that you have so much foundation to overcome an argument from the defense of all kinds of people are in financial trouble and don't kill their husbands. That's a direct quote from the court. All kinds of people are in financial trouble and don't kill their husbands. The court's gone full Legally Blonde.
Happy people just don't shoot their husbands.
The court says, with respect to the defense motion in limine number 8, respecting documents related to the 299 East 100 South property, the state cannot make arguments to the effect of the defendant dangled the prospect of home ownership to defraud her best friend since middle school. The state can't use those words, but the state can show that she sought a $45,000 or secured $45,000 from her friend and then use that money not to follow through with the representations she made to her friend. I think that's fair. Those aren't general guardrails. The court very much curtailed, and I think appropriately here, what they were doing. In trial, they say, the court went far beyond the court's pretrial rulings and introduced the testimony of Chelsea Barney and Brooke Carrington, going into great detail about numerous financial misdeeds. See attachments C and D, and those are transcripts of the testimony that we've watched. However, I think some of the detail came on redirect. So I think there were doors opened by the defense. They say Ms. Carrington spent an entire day on the stand testifying about bounced checks, false bank statements, misleading communications with lenders. Well, those false bank statements are part of what's charged here. Sloppy accounting, improper tax accounting, and on and on and on. Ms. Barney testified about how she lost her life savings and her home when Ms. Richins mishandled a real estate transaction. That's putting it mildly. When Ms. Richins mishandled a real estate transaction for her and allegedly lied about it. Oh, there's no allegedly about it. Girl. The defense objected to all the state's attempts to inject allegations of financial and business fraud and or dishonesty into the trial despite the court's pretrial rulings, and each and every objection was overruled by the court. See attachments C and D. The very beginning of the state's closing argument specifically referred to Ms. Richins taking out a HELOC without her husband knowing about it years before he died. See attachment E. Attachment E is a portion of the closing argument. But it's argument. 7 pages of the state's closing argument focused on the testimony of Carrington and Barney. So, Ms. Richins' case is similar to the case. No fucking way. Bingo! They're citing Murdaugh. No, they did not. Ms. Richins' case is similar to the case of State of South Carolina versus Richard Alexander Murdaugh. Opinion number 28329, South Carolina Supreme Court, May 13th, 2026, wherein the Supreme Court for the state of South Carolina, not the same circuit, by the way, held that it was overly prejudicial to allow the state, under the guise of proving motive, to introduce vast amounts of evidence showing financial misdeeds of the defendant spanning years of time prior to the murders of his family. Like the Murdaugh case, Ms. Richins was denied a fair trial due to the undue prejudice of financial wrongdoings preeminating her trial. The only appropriate remedy is a new trial. That is not accurate. That's not what the Supreme Court of South Carolina fucking said. That's not what they said. That's not what they said. That is not at all what they said. That is not why the case was overturned. That is not at all what they decided to do. You can't just throw the case in there and then completely misrepresent the finding of the Supreme Court of South Carolina, which, by the way, is not at all binding on the court in Utah. But I digress. That's not what they said. The fact that they only had like a page and a half of this indicates to me that they do not think that this is a very strong argument. I think they should have spent the majority of their motion talking about the financial crimes. Instead, they spent the majority of their motion stomping their feet that the judge was mean to them. They go on to say the court should grant Ms. Richins a new trial under the cumulative error doctrine. Under the cumulative error doctrine, a conviction should be reversed when 1, 2 or more errors occurred. 2, each error standing alone has a conceivable potential for harm. And 3, the cumulative effect of these errors undermines the court's confidence that a fair trial was had. Is anyone's confidence undermined in the Richins trial? They quote some case law saying that there's cumulative error, and then they fail to define any such cumulative error. They leave us all guessing at what the errors are. Conclusion: the court should recuse from consideration of this motion, and an evidentiary hearing should be scheduled before the judge assigned to the motion to present evidence and argument in support of Richins' request for a motion for new trial. Y'all, there is a free version of Grammarly. So they're asking the court to recuse themselves, and they're asking for an evidentiary hearing. Motions for new trial are normally just based on the motions. And they time warped themselves because this motion is dated June 30th, 2025. What evidentiary hearing do you want to have? More of y'all stomping your feet and saying the judge was so unfair? Because there's hardly anything else of substance in this motion. It is 14 pages of like, meh. Now we have gone through the entirety of Kouri Richins' motion for new trial. And what is staggering to me is that we did not see a ton of actual legal argument in an area where they could try to make an argument. I don't agree with the argument, but they could have put a bit more meat on the bone with the argument that the court allowed in too much of the financial crimes evidence under Rule 404B. Now, they also included other rules of evidence. I don't think those carry much water in this. But instead, they tried to say this case is just like the Alec Murdaugh case. They actually cited the Alec Murdaugh case in here and then misstated what the Alec Murdaugh case holding was. But they tried to say this case is the same. But then they don't take it a step further and lean into the arguments that Ms. Barney was incredibly sympathetic. And I think it's because they opened the door to a lot of the sympathetic arguments from Chelsea Barney. It was not a well done or well argued motion. And trying to find their legal arguments on some of the points, while they just don't exist. When they get to point 3, the argument that there's cumulative error, they don't even argue what the cumulative error is. They quote some cases and that's it and just move on. At the end, they do say that they're asking the court to reassign this case or to have another judge hear the case. They're asking, quote, the court should recuse from consideration of this motion, recuse themselves, be recused, reassign. And they're asking for an evidentiary hearing to be scheduled before the new judge assigned to the motion to present evidence and argument in support. I think this can be argued on the pleadings, but we're not going to see that until September because the prosecution has until September to file theirs due to scheduling. But there were a lot of legal arguments that just were left out of this. And it was a difficult motion to follow because it was not linear. It jumped back and forth with examples of, and the judge was rude to the defense here, and the judge was rude to the defense here, and the judge was disparaging to the defense here, and see, the judge cut them off here, and we edited together video from court. Here's the video. Let's see what the court did next. So this is what the court filed July 1st. Certifying motion for disqualification to reviewing judge. Judge M sent this motion to the PJ or the presiding judge and said, before this court is defendant's motion for new trial. On pages 10 and 11, the motion states in part, quote, because Ms. Richins is asserting herein a claim of bias on part of the judge, the court should reassign the consideration of this motion to another judge in compliance with Utah Code of Judicial Conduct. Given the apparent objective bias discussed, the actual conflict of interest created by allegations of this court's bias, and the need to ensure due process, disqualification from ruling on this motion is warranted. Out of an abundance of caution, the court interprets the foregoing as a motion to disqualify under Rule 29B of Utah Rules of Criminal Procedure. Under Rule 29B2A, the court hereby certifies the motion to the associate presiding judge of the 3rd District for review. Now, here's where I have questions. The court says the court shall take no further action in this case until the motion is decided. The court is treating what the defense has filed as a motion to disqualify. We are looking at Utah Rules of Criminal Procedure 29. We are looking at B, disqualification, motion to disqualify. B1A, any party to an action or the party's attorney may file a motion to disqualify a judge. The motion shall be accompanied by a certificate that the motion is filed in good faith and shall be supported by an affidavit stating facts sufficient to show bias or prejudice or conflict of interest. I don't think they did this. The court says that out of an abundance of caution, he is reading it as a motion to disqualify. But they aren't following the procedure. I think after looking at this more, that the Associate Justice of the 3rd District could very realistically bounce this back and say, no, this is not a motion to disqualify. It's an insufficient motion to disqualify. This is a motion for new trial. You need to hear the motion for new trial. I think this could end up going back to Judge M. I think the judge can't take any action until the motion for reassignment is decided. And the court is creating a motion out of an abundance of caution. We will have to wait and see what happens with this motion. I've not seen anything on the docket, but at this point, I won't be surprised if the judge that's reviewing this says that it's insufficient. I think based on the rule, it is procedurally insufficient because the things that need to be there are not met. And there are consequences that come with it. If you are moving to disqualify a judge or to reassign a judge, there has to be an affidavit. It has to be signed. And that can be subject to Rule 11 sanction. It carries a greater weight. So what is the defense going to do? I guess we're going to have to wait and see. Is Judge M off of this case today? No. We're paused. Could this go to a different judge to review the motion for new trial? Yes. But is there a possibility this stays in front of Judge M to review? Yes. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the LawNerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.